Well, good afternoon or good morning, depending on where you're at. This is a coast-to-coast privacy compliance webinar. Thank you for attending today. Today, we're going to cover some of the new legal developments in California, Colorado, Connecticut, Utah, and Virginia. Next slide. I want to first introduce myself. My name is Christina Gagne. I am a shareholder with Carlton Fields, and I'm also joined by one of my colleagues, Ed Marku, who will be presenting later on in the presentation. Both of us are knee-deep in compliance right now with both all the CPRA as well as the other laws that we'll discuss today. We will be answering questions at the end of the presentation, and so if you do have any questions, please feel free to use the Q&A feature and drop those questions in as we go, and at the end of the presentation, we'll try to address as many as possible. Next slide. Just so everybody is aware, this webinar is being recorded. After we conclude this webinar later this week, both the slide deck that we're going through right now, as well as a recording, will be made available to you. So look out for that email. And finally, a little more housekeeping before we get started. Next slide. While we are giving an overview of the legal landscape of privacy law, right now we may or may not be your lawyers. So this is not creating an attorney-client relationship. Any of the information given today is purely informational. And with that and the housekeeping out of the way, let's jump right in and get started. Next slide. So we'll cover a variety of things today in our hour. We have a jam-packed agenda. We'll first cover California's privacy landscape. We'll then turn to the 4 new states who have also adopted comprehensive privacy laws, talk about some of the similarities and differences that you may encounter with these states and their laws. We'll talk about enforcement of state privacy law, particularly we'll talk about California. There's been some recent enforcement actions that we want to bring to your attention. We'll go through our top 10 list of things that we do for our clients that we would advise that you do to jumpstart compliance. We'll talk about active privacy legislation, both at the federal and the state level. And then finally, we'll wrap up with questions and answers. Next slide. So we'll start with California, and we'll talk about the California Privacy Rights Act. Some of you may be familiar or not familiar that California currently has the California Consumer Privacy Act. It's been in effect since 2018, and it's been the law that a lot of companies have been striving to comply with. But we are California. I'm actually out of our Los Angeles office, and we often say we legislate first and legislate fast. And so California voters were not comfortable with the existing privacy law that we put into place a couple years ago. And so we do have a new law going into effect, the California Privacy Rights Act, in January. So we're about a little over 3 months out from that effective date. And so if you have not begun your journey with compliance with the CPRA or these other laws, this is a good time to start. I'm going to give a brief overview of the CPRA just so we're all on the same page with what it consists of and what some of the compliance obligations will be. Next slide. So these consumer laws that are coming on the books are really focused on giving consumers actionable rights. There's been a lot of conversation, and you can pick up any given tech publication talking about consumer privacy, the variety of data breaches and other things that we've come to be familiar with in the privacy and cybersecurity space. And starting in Europe with the General Data Protection Regulation, we've seen just this onslaught of trying to empower consumers over and give them autonomy over their data to the extent possible. So all of the laws that we'll discuss today are giving certain rights to consumers. And as a business, you have to figure out, how are you going to honor these rights if there's a legal obligation to do so. So just really briefly, I'll talk about some of the rights that currently exist under the California law, and all of these or most of these are in the other state laws we'll talk about later, but there are certainly all in the CPRA. So the first is the right to be informed and the right to access. So for example, privacy policies is a great example of this, having notice on your website and your mobile application of what data you're collecting, how you're processing it, and how you're otherwise using it. The right to access is very important. So if consumers want to know what data you have on them, the ability to access that data is paramount. The right to correct, the right to rectify is if you have data, on your website or within your application that could be incorrect, consumers have a right to update and correct that data. The right to deletion is exactly what it says, which is if a consumer wants their data removed from your ecosystem, they have the ability to do so. There's also the right to object or opt out of processing. So if a consumer does not want their data to be processed through your systems, they have the right to ask you to stop that processing. And then finally, the right not to be subject to automated decision-making. So if you are providing goods and services, in some sectors, this impacts them more than others. It's this idea that data is not being used to make snap decisions about consumers. Next slide. Two new rights, though, have emerged, and some of these are embedded in the other state laws we'll discuss in a few minutes. The first is the right to correct. So the right to actually correct inaccurate information. Businesses have to use commercially reasonable efforts when they receive a request. And so if you do receive a request to this effect, it's important that you have a mechanism in place to respond to that. And we'll talk about that in a moment. And the second thing is data minimization. This is a principle that, if you have a privacy compliance program, you may be familiar with, but it's the idea that you're only collecting data that you're actually using. I like to say use it or lose it. When I advise clients, we want to make sure that our clients are not holding on to any more consumer data than they actually need for their business purposes. And it does require a business to apply what's known as a necessity and proportionality analysis. So is this, information necessary for your business purposes? And then further, how much data are you collecting and how is it being applied, across your business units? And so these two principles are newer on the California landscape, and will become part of the enforcement process, as the CPRA goes into effect starting in January. Next slide. And just to continue, this is very important, is that data has a life cycle. We'll talk about data mapping towards the end of the presentation as one of our action items that we, endorse businesses to engage in as they begin the compliance process. But data, does have a life cycle. And so some things might be necessary at one point in a business process and not necessary in another. Or as your products and services evolve, you may realize that you're not needing to hold on to that data any longer. And so, having active data retention policies and really evaluating data on an ongoing basis and the liabilities associated with it are not just important to comply with the CPRA, they're also important just across your business units to make sure that you're not holding on to any data that could cause liabilities. For example, if you were to unfortunately, experience a data incident or a data breach, and you're holding on to data that you're really not using and isn't adding value to the business, that could end up being a much larger liability. And so it's important to continually be evaluating data. Next slide. The cure period for businesses. So under the CCPA, I believe that a lot of businesses were relying on a cure period, that if they were to, receive an enforcement letter or communication from the Attorney General's office in California, they'd have 30 days to fix the problem. That cure period is no longer in existence in the way that it is today in the CCPA. And so you really need to look at the CPRA and make sure that you are in compliance, because there won't be that latitude to give you notice of how you need to get into compliance. And we'll talk about an enforcement action that recently was released by the Attorney General's office towards the end of the presentation. But some of the things that the Attorney General's office is focusing in on are things that businesses are just sort of forgetting or hoping that they'll have time to rectify, as these statutes go into effect. So it's really important not to rely on the fact that, you might have like a prescriptive thing from an Attorney General's office or another consumer agency. You want to make sure you're ahead of the curve and actually complying with the law and the ins and outs of the law, not just relying on the fact that if something were to pop up, then you jump in and do compliance. And that has fortunately or unfortunately, been the posture of some businesses as they approach these consumer privacy laws. But, as the CPRA is going into effect, that no longer will be the case. Next slide. There's also an expanded private right of action. So one of the things that you want to look for as you evaluate how you're going to comply with these laws, but also as you assess liabilities that you may incur under these laws, is whether or not the law has a private right of action. So can individuals, bring suit against you for violation of the law, as well as not maintaining reasonable practices. And in California, the standard is reasonable security. So for example, if you were to have a data breach. And in the analysis, part of that would be, what were your security measures that were in place? And if there were any in place, which hopefully there are some in place, were they reasonable? And that's an analysis that, businesses need to undergo, in line with all the policy work that you will do to comply with these laws. You also want to look at your technology and other protocols to make sure that they're also meeting the reasonable security standard. And the reason this is important, and I think this is overlooked, is that this comes with probably the biggest financial consequence for a business should they be involved in a lawsuit, and that's statutory damages. So for every consumer who is impacted by the lack of reasonable security, for example, those statutory damages can tick up pretty quickly. And so as you're evaluating, your expenditures around privacy and security compliance and making decisions about the investment and such, it's important to wind into that calculus the fact that if you were to be subject to one of these lawsuits, those statutory damages can be quite overwhelming. And so this should be part of your calculus and risk management conversation as you decide how you're going to invest in compliance for both privacy and cybersecurity. Next slide. There's also new challenges for ad tech and marketing. There's a lot of very novel technology out there that allows companies to target consumers and try to get products and services in the hands of people who might want them the most. And so behavioral advertising is a great example of that. Individuals will now be able to opt out from the sharing of their personal information related to cross-contextual behavioral advertising. So if that's something that you've been using, as part of marketing for your business and trying to reach consumers, individuals have a right to opt out of that and not be subject to that marketing. And this could impact revenue streams for businesses who this is part of their business model. So some businesses on this call may use this technology to leverage it for marketing purposes and attract consumers to products and services. Others, this may be a part of your business model. You may have this embedded, and this is a revenue stream that drives the business. Either way, the CPRA is really clamping down on what you can do with individuals' information. And again, it's empowering consumers to be able to say, I don't want you using my data in this way, and they have the right to opt out from that use of data. And so it's important that you're aware that consumers have the right to opt out, that you're providing a mechanism, on your website or in your mobile application or through your platform for that individual to opt out, and that process is clear. So all of these laws are oriented around making this as consumer friendly as possible for the consumer to manage their personal information within and around your data ecosystem. Next slide. Sensitive information also will have new treatment. And so the use of sensitive information is now more restricted than it was under the CCPA. And individuals also get to opt out of the sale or sharing of this category of information. So again, you have another category of data that your company may collect, and consumers have to have the ability to opt out, and it should be a very easy and streamlined process. Next slide. And just for reference, what is sensitive personal information? Some of these things are fairly obvious: social security numbers, driver's license, passport, financial information, data related to race, ethnicity, and religion. Next slide. And some of the newer categories that I do want to highlight that I think are important are genetic data, as well as biometric data and health information. I know a lot of companies are beginning to leverage artificial intelligence and biometric technologies. They can be very impactful and powerful in terms of driving a business forward and engaging with consumers. But these are two areas that you are seeing be more heavily regulated. And so outside of just the California Privacy Rights Act, other states and actual local governments in some instances are passing laws specific to this information. Next slide. There's also changes to vendors. So under the CCPA, if you have been doing the compliance, or if you've been in and around other CLEs, You probably kept hearing third-party service provider again and again and again, and service provider. Those are still all entities that are regulated as well under the CPRA, but there's also a new covered entity that was introduced, or language around that, and that's the use of the word contractor. The CPRA is a lot more zeroed in on having contracts and assigning data liabilities throughout the entire supply chain, throughout the entire ecosystem of how you do business. And so you may need to go back to your existing contracts and revise them to include provisions that address data liability with vendors. You may also want to have separate, exhibits to your contractual agreements, like a data processing exhibit or a data security exhibit. Many times those are a hybrid addendum to a contract, but you really have to go back and evaluate, how you're entering into business relationships with your contractors, your vendors, your third parties, and see and make sure that all data liabilities are assigned. The other thing that you're going to want to look at aside from data liabilities is cybersecurity practices. There hasn't been as much of a focus on ensuring that vendors have security protocols in place. So if you are using a third party and you are sharing information, it's not just how you maintain your house in terms of cybersecurity that's important. You really want to evaluate, what are your vendors doing? So if you're trusting a vendor in a relationship, you want to evaluate what are their security practices. And so we'll discuss some tips in a little bit here, but you do want to make sure that your contracts are very clear about liabilities and very clear about expectations for both you as well as your vendors. You also need to now have in place measures to monitor compliance and have audit rights and agreements. So for example, if a vendor is telling you, yes, we do these, 7 or 8 security things that are in the contract, you want to make sure that you're actually auditing for that you're actually verifying that those things are in place, that you're actually seeing those policies, so that if there is a data incident or something happens in the chain of custody with data, the contract addresses that, but also there's a process in place for who will be liable. Next slide. There's also a new enforcement arm. So, I've been practicing privacy law for quite a while. And, as a practitioner, I often hear, am I really going to get in trouble? Like, is this actually going to be a liability for me? Because privacy is seemingly still, a very new area of law, even though it's been around for a while. And a lot of the conversation is, who's going to come after me? In California, one of the things that was changed from the CCPA was to form an actual agency that will now be the enforcement arm. So there is an agency in California that is solely dedicated to the enforcement of the California Privacy Rights Act. And so the AG's office in California has been, I think, fairly aggressive. Our Attorney General, Rob Bonta, has been a little more aggressive than past attorney generals in terms of, enforcement through his office. But once the CPRA goes into effect in January, I would imagine that enforcement is probably going to escalate. And so it is really important that with the, advent of this new agency, that companies really use the next couple months to get into compliance as quickly as possible. Next slide. I will now turn it over to my colleague Eden, and she will take us through the other 4 states that have also passed comprehensive privacy legislation.
Thank you, Christina. So now that we've talked about California, we have 4 additional states that have passed their own comprehensive privacy law similar to the CPRA. So all 4 laws will actually take effect next year, 2023, hence the year of privacy compliance. Each privacy law has their own threshold and their own obligations, so it's important to review each one in detail. Next slide. So in order to determine whether or not these laws apply to your business, we first have to look at 2 important definitions that come into play in the privacy context. So we have personal information. Personal information is what you probably think it is. It's information that relates to a particular consumer or household, or whether it's directly or indirectly. So that's your first and last name, your physical address, so on and so forth. You also have the definition of sale, and sale is actually, when you think about it in an ordinary context, you're thinking some money is involved, but actually in the privacy context, it's a little bit different. So we have a statutory definition here, but it is essentially selling a consumer's personal information to a business or a third party for monetary or other valuable consideration. Now, this is a definition for 3 states, Colorado, California, and Connecticut. And you can notice here that the most significant part of this definition is the other valuable consideration, meaning money does not have to be involved and it still may be considered the sale of personal information. Next slide. Great, so now that we know what sale and personal information means, it is, we first now have to determine whether or not these laws apply to you. So it's really a 2-step process, but right off the bat, we'll address a common misconception, which is my business doesn't make 25 million in annual revenue, therefore these laws don't apply to me. That is not accurate unless you're in Utah. If that is the case, you're making less than 25 million in annual revenue, then the Utah law does not apply to your business. That is not the case with the next 4. Those are, like I said, a 2-step process. So you're asking yourself first, are you conducting business in the state? Are you collecting their personal information, the state consumers? Are you marketing your products or services to these consumers? And if you said yes to one or both of these, depending on the state law, then you move on to the second question. But before we move on to the second question, we'll look at the enforcement dates below. You'll see we have 2 in January coming up, 2 in July, and 1 in December. Next slide, please. So like we just said, we have the first step. If you met that, then your second question is, you have 3 different triggers under the second question. So all 5 privacy laws have the first trigger, which is if you are controlling or processing 100,000 or more consumers' personal information, then you do have to comply with the law. However, there are 2 different options. Even if you did not meet this, then you may need something else. Next slide. So if you didn't meet the 100,000 person threshold, you may meet one of these as well. So you have to ask yourself, are you deriving revenue from the sale or sharing of personal information? And if so, how much? And we've actually laid out the thresholds. You can see that there's a little variation depending on the state right here. Now, this is a second trigger, but California does have a third trigger. So if you don't fall under the first 2 and your company has over 25 million in annual revenue, then it still does need to comply with the CPRA. Next slide. So earlier we talked about consumer rights and we went through the right to know, the right to data portability, correction, deletion, opt-out, and to limit use and disclosure of sensitive personal information, the new category of personal information. You can see here that every state has the right to know and the right to access along with data portability. And data portability essentially means that you get a copy of the personal information that the business has about you. The consumer obtains a copy of the personal information. The right to correction is also available in each state other than Utah. So the consumers do not have the right to correct their personal information that you hold. We have the right to opt out, and there is some variation. You'll see the consumer has a right to opt out of the sale of their personal information in all states, but then it varies between targeting, advertising, and profiling in others. And the right to limit use and disclosure of sensitive information is available in California, although it is limited to, it only applies if it is used for a consumer's, if it is used to track a consumer's tendencies. If it is not used for that purpose, then you do not have to process such a request. Next slide, please. We mentioned this earlier, but the CPRA elaborated on their private right of action. They actually added to it. Before, it was a consumer was allowed to bring suit to the business that is responsible for processing, collecting, or holding their data for any instances of the breach of their personal information. So if I'm a consumer and you had my information, it was impacted in a breach, then I have the right to then sue you for that incident. Now, with the CPRA, if there's a breach and my email address was affected, along with information that allows access to that account, then I can also bring suit. Now, information can be the password to your email or a security answer and a security question and your answer to that question. Next slide, please.
Now we want to discuss a recent development or somewhat recent development in enforcement of the existing California Consumer Privacy Act. And that is a settlement from the state of California against Sephora, which is a very well-known consumer brand. And we'll talk about sort of the anatomy of this, what Sephora failed to do, what the consequences were. And, if you're looking at these types of enforcement decisions and settlements, how do you evaluate how your business, could be impacted if you were to be in a similar scenario? I just want to make a brief comment that the Attorney General's office has put a lot of information on its website about its privacy enforcement. And if you were to just do, a casual review, it becomes pretty obvious pretty quickly that they're going after a variety of different companies. So these are not all large incumbent companies. Some of these are startups. It's across industry. So enforcement is industry agnostic. And I really want to make that point because I think that it's easy if you are already in an industry that is heavily regulated, so finance, healthcare, to say, well, we're in these heavily regulated industries. What do we have to worry about? Well, this is a separate law with separate requirements. And oftentimes when you are in a heavily regulated industry, some of the marketing and other things that you may do would still fall under the auspices of the California Privacy Rights Act. So you might also be a company that isn't a large company, but you are doing a volume of consumer transactions. And so you might also say to yourself, well, how likely is it that I would be a target of AG enforcement? The answer is that I think that given what the AG's office has done, plus the fact that there's going to be a new enforcement arm that's just dedicated to enforcement of the California Privacy Rights Act, any company could be a target. And so I think it's very important to evaluate and come up with a plan now so that over the next couple months, you are ready for when that, enforcement date hits. So what does Sephora, fail to do? First and foremost, and this is something that is very easy to rectify working with counsel, which is disclosing it was selling personal information. So, if you are going to incorporate the sale or sharing of personal information as part of your business model, or through partnerships with other companies or entities, it is really important that you are disclosing this to consumers. Consumers have a very distinct right to know about the sharing and sale of personal information. And so this is one of the things that the AG's office focused in on in terms of Sephora's privacy practices. It was also not able to or was not processing user requests to opt out of the sale of personal information. So one of the things that we discussed previously in this presentation is your consumer controls and consumer rights access needs to be user-friendly. It needs to be something that consumers can very clearly know how they opt out and how they effectuate those rights. And so Sephora had similar problems in it was not clear to consumers of how to opt out or they weren't truly being opted out. And then third, actually cure the violations during the cure period. Now, as we've discussed, there is not going to be this, I will call it a luxury of a cure period moving forward. But even when the AG's office put them on notice in regards to, what was wrong with their privacy programs, it wasn't rectified. And so, Sephora then was subject to, more enforcement, beyond the initial notice and beyond the initial cure period. Next slide. So my favorite question of all time as a privacy practitioner is, what are the consequences if I don't do this? I hear that again and again. It's not a novel question, and I understand why it's asked, which is, we're going to make an investment in this. It has to make sense. So Sephora ended up settling with the AG's office. There were $1.2 million in financial penalties, which is a hefty sum for any company. But I think more importantly, what I want to focus on is that there's also a remediation plan. So oftentimes, if you are subject to enforcement, and you are subject to an investigation, you might end up in a settlement arrangement with a given regulator. You're probably going to be subject to a remediation plan, which means that you're not just paying your fines and walking away. The AG's office or whoever the regulator is in a specific state is going to be over your shoulder for a period of time, making sure that you remedy the deficiencies in your privacy or cybersecurity program. So just some examples of what's in the remediation plan from the public settlement agreement, with Sephora. They have to clarify their online disclosures and privacy policy. So they have to actually update their policies to make it clear to consumers they're selling data and sharing data. They have to provide mechanisms for consumers to opt out of the sale of personal information. They need to conform their service provider agreements to the CCPA's requirements, which will be the CPRA in short order here in a couple of months. So that was also something that there was a deficiency in service provider agreements, and then provide updates to the Attorney General. So this is not just a matter of, arriving at a settlement. And again, that's the end of it. These are ongoing relationships, if you will, between the regulators and between the companies, where they're going to be checking up and making sure that, they are in compliance with the law. And so that won't just impact the violations that they had previously. The AG's office is going to have a keen eye on what a company does moving forward. And so it's really important to understand that, this isn't just a calculus about fines and penalties. This is a calculus about fines and penalties. It's a calculus about a remediation plan and having to, kind of be under the eye of a regulator and answering to a regulator. And then additionally, as Eden has pointed out, there's private rights of action in these laws. And so you're dealing with, litigants who can also come after you for statutory damages. So to answer the question of why is this important beyond just respecting consumer privacy, there can be real consequences for businesses, both operationally and financially. Next slide. So we've delivered, and I love these CLEs when they're top heavy and we're telling you all the things you have to do, and then it becomes a little doom and gloom. But this is the positive side of it, which is things that we would recommend. So, these laws can seem, and we represent businesses of all shapes and sizes. Our practice jointly is industry agnostic. And so we've been working with a variety of businesses for CCPA compliance. And then clearly, in the last, about 14 months with the CPRA. So we're going to share some tips of things that we advise our clients to do. And again, we do this with small companies to Fortune 500 companies. So this is not something that is just for big companies. I think that this approach can be tailored depending on the size of your business. I think that if you are really to look at these items and get them going prior to the compliance deadline, being in compliance prior to January 1st for California, and also, the other laws that are going to be, hitting enforcement deadlines in 2023, I think you can be in fairly good shape. So just quickly, I'm going to go over our top 10 list, and then we'll give you a little more color around what we mean when we use these terms. So top 10 is, number one is data mapping. The second one is a privacy impact assessment. Third is drafting your internal policies and creating your data management processes. Number 4 is external notices and disclaimers, so privacy policies. 5 is creating mechanisms to respond to and honor consumer requests. Next slide. 6 is employee training. 7 is vendor management. 8 is revising and creating contracts. 9 is security protocols, and 10 is my favorite, rinse and repeat. Privacy is definitely an ongoing process. And as your company evolves, how you interact with data and leverage data will evolve as well. So let's turn to the first step. Next slide, which is data mapping. It's the foundation of every single data privacy program. Even if you have an existing data privacy program, it's something that you should be doing in as frequent of intervals as possible. This is knowing what you have from a data perspective. It's having a comprehensive understanding of what your data ecosystem is. And this varies for every single company. Some companies are dealing with a very discrete set of data points, and so this process is a little more straightforward. Others have multiple business units or subsidiaries, or just the things that make your business thrive are also very data heavy. And so this is the point where you figure out, what is the entire ecosystem? Where is all the data? And that includes not only consumer data, but employee data as well. And so this is where you get a handle on what data you have. And this can be something that is involved. So we have clients who use software to help them effectuate data mapping. We also have clients who, use spreadsheets and have a list of data and where it is across business units and who has access to it. And this is something that, certainly Carlton Fields can assist with, but this is the underlying work. Before you do anything else, draft a privacy policy. Before you are engaging with vendors or amending contracts, you want to have a really salient understanding of what are all the data points that you have liabilities for. So this is really important. Step 2, after you data map, and next slide, is a privacy impact assessment. This is a newer term in the privacy space to a lot of businesses, even though the concept has been around for a while. It's essentially an audit of your data and security practices where you identify risks and then remediation that might be required. So a great example is a data retention policy. So, we've been working with a lot of clients this year due to these new laws who previously didn't have a data retention policy in place. And so when we did an impact assessment, one of the things that we identified was, well, you don't have a data retention policy saying how long you hold data. So what is the type of data and how long is the company holding it? How long are they legally allowed or legally complied to hold certain data? And so we would identify that, that's a risk, not having one. And so the remediation would be, okay, let's get that policy drafted and get it in place. So that's really what a privacy impact assessment is. Clearly, it's a little more involved than we have time to, walk through today. But the idea is that you're looking across your business and identifying any risks from a privacy and cybersecurity perspective, assigning a value to those risks, and then figuring out, okay, we know what our risks are, how do we remediate them? And then prioritizing those remediations, because some privacy risks will be much smaller than other privacy risks. And so you want to figure out, what your game plan is out of that impact assessment to remediate and establish either technology or policy protocols to remediate those deficiencies. The other thing you do in this process is you develop a risk assessment that you apply to all of your practices. And so once you do this, in the first year that you do a privacy impact assessment, that's a baseline. You can then build off that baseline moving forward. And so one of the things that, we do with our clients is, and we have recommendations for this, but every business is different, is we help them build that risk calculus. We help them figure out, how are we assigning risk? Some of that is likelihood of impact. Some of that is, okay, we're looking at the landscape and what enforcement looks like. But this is, I think, a critical part because this will be the foundation of how you, at whatever interval, you'll be updating your privacy programs, which under many of these laws on a yearly basis, you have to revise and update your privacy impact assessment. You want to be prepared to be able to do that. Next slide. Item 3 is your internal policies and data management. So once you have your data map, once you have your privacy risk assessment, you then want to look and say, okay, what policies are we missing? What needs to be drafted? And these are the internal policies that you reference in order to support privacy and security across your business units internally, but also, how you're interfacing with consumers. So 2 examples that we're routinely working on, I've already mentioned data retention policies. Another thing that's emerged, and I always like to remind businesses that employee data is also a part of this process, not just consumer data. A lot of businesses are still hybrid. A lot of people are still remotely working. And so many businesses have decided, for example, to use employee monitoring technologies. Well, you can't just drop a technology and have employees using it and not have a policy around it, not have a policy around, giving employees notice and when it's used and how it's used. So those are the types of things that you do internally that will help power the rest of how you leverage data, across the business. Next slide. Item 4 is your external notices. So once you have your internal housekeeping in place, you have your internal policies and technologies in place, you're working on your remediation plan, you then would draft a privacy policy and other disclaimers to provide to consumers, to provide to your employees or any other third parties which legal disclosure is required. And so, this is something that is very cosmetic. And I think that a lot of businesses tend to lean towards privacy policies as their first step because the thought process is if I have a privacy policy on my website, isn't that what's required of me? And in some states, yes, that's still the requirement. But under these new comprehensive laws, you basically just skipped 3 steps before this. How are you putting in your privacy policy what data you collect and process if you don't know what that data is? That's impossible. And so this is something that once you have the other 3 steps in place, it's a lot easier to put these external notices. An example is, if you are, using third-party tools, you want to disclaim to consumers you're using those third-party tools. I just gave the example here of artificial intelligence and biometric data because that's something that is being used a lot more prominently by businesses today. Next slide. The next action item is consumer rights. So you need to make sure that you have a process in place to effectuate the consumer right. So the example that I'll use is data deletion. So if you put in your privacy policy that, we comply with the CPRA and the other state laws, and this is a right you have, data deletion, you're basically telling the consumer that they have a right that they can effectuate. And so you have to have a pathway for that consumer to actually effectuate the right. So who are they contacting about deleting their data? Who is supporting that request? Which part of your business teams, who is in place? Is it your marketing department? Is it some other department that's actually responding to the requests? Are you using a third-party vendor to respond to the requests? Are you using legal counsel to respond to the requests? Like, all of this needs to be documented in a policy. Technically, can you respond to the request? One of the challenges that some of our clients have had is actually deleting the data, for example. So as we have workshopped sort of, how are we going to honor these requests? It becomes obvious that deleting the data might not be as easy as one might think. It depends on your business. And so you want to make sure you actually can technically not just say you're going to honor the request to the consumer through communications. You need to be able to go back on your back end and through your technology and actually remove the information and have an audit trail that you did remove the information. And that's the final point, is all of this should be documented in an audit trail. So from the first communication you get from the consumer, the response you give the consumer, the actual, if you decide that you have to honor the request, and then if you do honor the request that you actually did. So for example, the right to know, right to access, you gave the consumer a copy of their data. The right to delete, you can prove to the consumer their data was deleted. So all of these requests have to actually be actionable. You can't just put them in your privacy policy and say that you are honoring these requests if you really don't have the mechanisms in place internally to do so. And this is probably, this can be a little more of an involved process, but we found working with our clients that we're able to create workflows and create systems that we can help plug into our clients and make this a lot easier. Next slide. Item 6, I cannot underscore how important this item is, and I think this gets overlooked continually, and it's employee training. Employees are your greatest asset, but they can be your greatest liability if they don't know what they don't know. And a lot of employees are not aware of consumer privacy laws. So all of these laws require employee training. They require employees to have a baseline knowledge of the laws. So for example, a general training to all of your employees about the California Privacy Rights Act. And then specifically, if you have a unit that's going to be the unit responsible for enforcing the CPRA within your company and responding to consumer requests, those employees should be specially trained on the consumer rights and how to respond to consumer requests so that they know how to actually put the law into effect internally. So this is very important. I also want to underscore here that it's not just training on the laws that we're talking about today. It's also training on cybersecurity. I think that's often overlooked. A lot of employees don't know what risks to look out for, or they don't understand phishing scams and other things that businesses are, engaging with frequently today, unfortunately. So employee training is invaluable. This can really help to reduce risk if employees are armed with the information they need in order to follow these laws. Next slide. 7 is vendor management. This is also often something that's overlooked. When you enter into a business relationship, particularly with data, you want to make clear who's on the hook for what. And if your vendors don't have, best of breed privacy and security practices, and they have an incident or they mishandle data, you're not going to escape liability for that. You will have liability for that as well. So things that we recommend are having a vendor management policy in place, which actually has a process for certifying that the vendor understands and is in compliance with the data privacy laws that we're discussing today. This is vendor due diligence is exceedingly important. And so actually having something in place like a vendor questionnaire or something that vendors actually have to go through and verify that they've taken certain steps, that now has to be a part of vendor onboarding. Particularly around security protocols. So there's lots of different certification programs that are out there. There's the SOC series, there's other series that are available. You want to make sure that depending on your business and business requirements, that if a vendor is saying, yeah, we're SOC compliant, like, okay, well, can you just share the policies that you have in place that verify that? So this isn't just taking, a vendor's word at, yes, we have this in place. It's actually going through the diligence and making sure that if you're going to share personal information with that third-party vendor, service provider, business, that they have practices in place that you trust, that if you share that data, you're not going to be walking into a set of liabilities that you're not aware of. Next slide. Item number 8 is revising contracts. So again, we tried to prioritize these items in an order that makes sense in how we work with our clients. Once the systems are in place, the policies are in place, we can then look at the contracts and revise the contracts to address liability, to address, restriction of use. So one thing that the CPRA particularly narrows in on is restricting the use of data to third parties for the exact purposes that the third party needs the data. You also want to look at, your contract ecosystem. Each business is different. You know who you're working with. Does it make sense to have separate agreements around data liabilities, to embed them in existing agreements? These are all things that, depending on the business, a certain way to do contracts and enter into agreements works for some businesses better than others. So given your own, business development and contractual ecosystem that currently exists, Data Privacy Council can help you figure out how do you plug all this in a way that doesn't create friction, which I know is always a concern with our clients, is I don't want friction in that business process, but these data liabilities now exist and need to be accounted for. Next slide. Item number 9 is appropriate security protocols. So we've talked about the private right of action under the CPRA, but this is not just a matter of you could get sued and there's statutory damages. This is where, we're seeing a lot of our clients and clients that come to us having issues is they just don't have the technology and policy solutions in place that are working with one another to help protect their business information. So multi-factor authentication is an example, but even, enhanced email systems. So those of you that use Microsoft Office 365 or some of the other providers, there's tiered offerings, and those tiered offerings come with enhanced security. And so you want to make sure that you're evaluating these solutions and trying to use the best solutions so that if you were to have a data incident, it's easier for you to investigate, it's easier for you to respond. And so those are all important things to evaluate. So again, privacy and security, particularly security is not a place to cut corners. So if there is an offering that you're using, across your business units, if you're using a software as a service and they offer an enhanced, service that has more heightened security, you may really want to evaluate that, because that investment could definitely be worth it down the line if you ever have an incident. From a policy perspective, having policies in place around the acceptable use of the internet and your programs, passwords and how passwords are created, third-party access to information, third-party access to your physical locations, third-party access to your online systems, and then actually having an incident response plan. So, one of the things that, again, we often do as lawyers is, we have to worst case scenario. That's what we're there for. But having that response plan in place, both Ed and I do data breach response work in addition to our compliance practice. It just makes things much easier in what is already a frenetic scenario with a data incident to have that game plan in place and be able to move forward. And finally, and then we will jump to questions, is next slide, is item 10, which is basically rinse and repeat. This is an ongoing process. This is not something that you just put into place and it is static. You should be reviewing your practices year over year. If this is the first time you've really evaluated comprehensive, privacy compliance, the first time you do it is definitely a little more involved. But once you have those processes in place, it becomes so much easier to evolve a compliance program. And so the foundational work that you put in to comply with the CPRA and the laws in the 4 other states that we've discussed today, it will definitely pay dividends after that initial investment and be a lot easier. And this has to be annual. So one of the things that these laws require is they really want businesses on an annual basis, or require businesses on an annual basis, to be evaluating their data privacy practices. So you're going to have to do it to comply with the laws. And so it's just better to, get your game plan in place, evaluate how you're going to do compliance quarterly, biannually, annually, and you'll work with counsel and work with security vendors to assist you in doing that. Next slide. And so now we'll actually turn it back to Eden to talk about the American Data Privacy and Protection Act, and we'll do a brief review of other state laws coming.
Great. So if you haven't heard already, we are receiving some privacy movement on the federal front rather than the state front this time, although the states have attempted to fulfill the void for the federal.
I think we may have lost Eden, so I will jump in here. I know we are having some issues out of Florida today, clearly due to the weather. Just a little background on this. I've been practicing privacy law for quite a bit here, and there's always rumors about, well, where's federal privacy legislation? I know for businesses, having worked intimately with businesses throughout my career, having all these different laws in different states, can be a little onerous. And so there's always this hope that there will be federal privacy legislation. This bill, HR 8152, has definitely made it further than other privacy bills have. Most of them sort of die pretty quickly. It's industry opposition or other movements around the bill. But this one would, create a national standard around consumer data privacy. So we've just shared a little bit of information on it, just so you're aware this is actually happening right now. Next slide. And it's very similar. The requirements would be similar to what you see in the state laws. So, the same requirements around consumer rights, the same requirements around the management of data, all of that is included in this law. And then it also requires a privacy impact assessment. But to be candid here right now, I don't think this is going anywhere. So for all the hopes that there would be a federal privacy regime, that we could just follow the federal regime, I don't hold high hopes, nor do my colleagues hold high hopes that this is actually going to be put into law. Next slide. I want to talk a little bit about state level movement. So 2/3 of states have considered comprehensive privacy legislation. If you were to talk to me 4 years ago, I would have thought that impossible, but you're really seeing movement on privacy. It's a cross-partisan issue, and you're seeing states really try to be aggressive about this. Key states that are still actively in session: New York, Michigan, and Ohio. So their legislative sessions aren't over. And so our firm is monitoring where those bills go before the end of the session. Next slide. But just to give you a visual of other states, here's 18 other states that are also, talking about comprehensive privacy regulation. So this isn't a California thing. It's not a coastal thing. It's something that you're going to see this pop up state by state over the next couple of years, to where we get to a point where a majority of states will have comprehensive privacy regulation in place. So as you are evaluating, am I wasting time, complying with California or Colorado or Utah right now, I think the answer should be a resounding no. What you invest in privacy and security compliance right now, these laws are going to mirror to a large extent the laws that currently exist. We saw that with Virginia and Utah, Colorado, and Connecticut. They have a lot of similarities to the California law. So I don't think states are going to go far afield of what you're already seeing in terms of requirements. And so not only are there enforcement deadlines that are looming over the next year, but there's also other states that are going to jump in on this and also have their requirements. Next slide. Great, questions. So we have a couple questions here. We'll start with vendor oversight. There's a question regarding whether the CPRA specifies security metrics that must be audited against. Unfortunately, no. We have a rubric that we've developed in our work, because we help clients do SOC compliance and a variety of other things. And so, and also in complying with some other state level laws, we have a rubric that we help our clients with, but there aren't specific requirements. One of the things that has been frustrating for businesses is that the law has, or the CCPA and the CPRA has, a reasonable security standard. What does that mean? That's a favorite thing of lawyers when there's a reasonableness standard. Like, what is reasonable? Like, what do you mean? And as a business, what does that mean? So, we turn to existing industry protocols. We turn to other states like New York's Department of Financial Services has requirements. And so we look to other laws and help us to guide our clients as to what that means, what reasonable security may mean, and what should be in place. I did see a question as well, and we just addressed this, but I'll revisit it again, is, how many states, do we expect to enact new privacy laws in 2023? I would say, 4 states were able to get this over the line in the last year. Very different states as well. I want to note there's not a lot of similarities between these states. And so, I would expect that we're probably going to see, at least 4 or 5 more in the next legislative session. I think some states might be watching what happens as these laws roll out in California and Virginia and other places, and see if there's things that maybe they need to adjust in their laws. But I would not be surprised if we were having this conversation next September and we were doing a whole new presentation on 4 or 5 other states and the laws that have been passed. There's also a question about, I'm sorry, I'm just reading through the questions here, so I'll try to get to all of them before the end of the hour. There's a question about which state has the strictest data privacy laws. And then when communicating with IT teams, would it be our recommendation of whether to adhere to these strict laws to ensure national compliance? So I will say that I always try to endorse my clients to go with the strictest law, with the caveat, because lawyers love asterisks and caveats, that some of these states have little things in the law like deadlines. So for example, consumer response deadlines that are different. So one state may require you to respond to a consumer in 10 days. Another state may say 15 days. And so, you can't in that particular instance just say, what, we're going to go with California because those deadlines are different. But I always advise my clients, like, pick the strictest law. Understand what there's idiosyncrasies between these other laws, but if you go with the most strict interpretation, you'll probably be in a good position. That being said, someone else asked another question, which I think dovetails into this perfectly, which is states considering, industry-specific legislation, including biometrics. So several states right now have biometric data laws in place. Illinois is probably the most well-known, Washington and Texas. A couple local cities actually have biometric data laws in place. At the legislative level, one thing that we're tracking is these biometric laws as well as AI laws. I think you'll see a lot more of that next legislative session as well. So aside from these comprehensive laws that we're talking about today, I think you're going to see a lot more industry-specific laws. We're seeing a lot more heavy regulation about specific industry practices. So the insurance industry and marketing, we're seeing more regulation that's specific to the insurance industry and marketing itself. We're seeing a lot more siloed stuff. And so I know today we're talking about these big laws and these compliance requirements, but there was also a flurry of activity on individual privacy practices or individual, subsets of industry that passed through our state legislatures this year. And so it's important to, liaise with legal counsel and figure out, what else happened besides these large laws. We are almost at the top of the hour. Let me see if I can answer anything else. Somebody did ask about how sharing is defined in the statute. It's in all of the statutes, but I'm gonna go back to a comment that my colleague made, Eden, earlier in the presentation, which is, sharing and sale can mean a variety of different things. So the sharing of information, you could be using it in some sort of partnership arrangement, not a financial arrangement. If you are giving data to a third party to effectuate something that's part of your business case, you should have got that probably is going to be sharing. So I would err on the side of, if someone else is getting it besides your business, besides the consumer making a request, you could be engaged in sharing or sale. And so it's important to sit down with counsel and walk through how you provide products and services and see at what point, as in your data ecosystem, as you may be sharing or may be selling data, whether or not that's the case. We are at the end of the hour. I want to encourage you that if you did not get your question answered, or if we have just overloaded you with information today, I know we ran through a lot in an hour. If we can go to the next slide. Please feel free to reach out to Eden and I. We are doing this day in and day out with different businesses. We'd be happy to assist and answer your questions. Like I said earlier, we'll be sending out this slide deck, which has our information, but feel free to give us a call or an email. That this is what we do. We are knee deep in helping our clients do this right now. And so, if you have any particular questions, I saw some questions also about, not these laws, but other privacy laws. Our practice, again, is pretty industry agnostic. And so we're helping all sorts of great clients in different industries try to comply and support their business practices. But I want to thank everybody for being on this webinar today. Again, it will be sent out via email, both the recording as well as this PowerPoint deck that we went through. And I hope everybody has a wonderful afternoon. And for those of you near the eye of the storm, I hope everybody is safe.